new members here, I think it would be useful for us to go around the table and just identify ourselves. My name is Robert Devlin. I'm a Superior Court judge, and I'm chair of the Connecticut Sentencing Commission.
Bob Farr, former state representative and state chairman of the Board of Pardons and Parole, and I'm a member of the commission.
Good afternoon. I'm James Ravella from the Department of Emergency Services and Public Protection.
Mark Palmer, the Chief of Coventry Police Department.
Tom Kulhowick, the Chief, Norwalk Police.
David Sheepak, State's Attorney's Office, Litchfield.
I'm Kevin Kane, the Chief State's Attorney.
Judge Pat Carroll, I'm the Chief Court Administrator, and Judge Devlin, in a few moments, I just have to step outside for a meeting with Senator Kissel, but I will return, okay?
Christopher Pillow, I'm the Chief Public Defender.
Hillary Strackbein, Superior Court Judge in New London County.
Gary White, I'm a Superior Court Judge. I sit in Stamford.
Good afternoon. I'm Gary Roberge, the Executive Director of the Judicial Branch's Court Support Services Division.
And I'm Roland Cook, Commissioner Designate for Department of Corrections.
I'm Leland Moore. I'm sitting here on behalf of Carlton Giles, Chairperson of the Board of Pardons and Paroles.
Thank you for that. Good afternoon. My name is Mark Palka. I work at the Office of Policy and Management as Undersecretary of Criminal Justice Policy and Management.
Good afternoon. Alex Tarkov. I'm the Director for the Commission.
So I'd like to take this opportunity to welcome our three new members to the Commission. James Ravello from the Department of Emergency Services and Public Protection, Roland Cook, and Mark Palka. Thank you very much. We look forward to working with you and your expertise in helping us do our work. So thank you very much. So the first sort of substantive item, I should mention we have one vacancy on the Commission right now, which we hopefully be filled relatively soon. The next item on our agenda, Roman numeral number 3, is approval of the minutes from the December 19th meeting. They were circulated earlier, and I think you've had an opportunity to take a look at those. Is there a motion to approve the minutes from the December meeting? Second? All in favor, please say aye. Aye. Any opposed? Okay, carries. Minutes are approved. So we have a fairly robust legislative agenda that we are hoping to put forward to the legislature this session. We have presented these bills, and Alex and I and others have met with some of the legislative leadership to sound them out on their understanding of what our bills are trying to accomplish. And so I'll just go through them just briefly. These have been product of our earlier votes, but just to remind everyone, we have made a couple of different proposals regarding our sex offender laws. With respect to our laws against possession of child pornography, we've made a proposal that persons who have convictions of sexual assault should receive an enhanced penalty if they're found in possession of child pornography. That's based on a study that showed that people who have a prior conviction of sexual assault are much more likely to be contact offenders or try to be contact offenders, and I think deserve some more firm punishment or firm treatment. At the same time, there are persons who have developmental difficulties and problems that are evident who get sort of caught up in this child pornography situation and may not need a jail sentence, and so the proposal would also give a judge a discretion in the right case for good cause shown and reasons stated on the record to deviate from the otherwise mandatory sentences. So that's that proposal. There's also a proposal there with respect to sexual assault in the second degree, that for people who are, for younger offenders, the judge would have the discretion in the proper case to deviate from the 9-month mandatory minimum in connection, which is presently in the law with respect to sexual assault in the second degree. Number B there is our comprehensive recommendation with respect to revising the sex offender registry, the product of our 2-year study, the report that we filed with the legislature. Again, we've had extended discussions about this, and this is a proposal that we've presented to the legislature again, and we'll see how that goes. And then the that third C is a series of proposals that we've put together in sort of one bill And just, again, to summarize these things relatively briefly, we made a proposal that would reduce the penalty for a Class A misdemeanor from 365 days to 364 days. It's a very modest change in our law in Connecticut, but may have a major change with respect to the ability of persons who are in front of an immigration judge to get the benefit of some flexibility that the immigration judge might have, which is not available for persons who are convicted of felonies. It's, I think, as we mentioned before, there's this very unusual situation where this exact 1 year line is the top of our Class A misdemeanor penalty, and under federal immigration law is the bottom of their, it's the top of our misdemeanor class and the bottom of their felony class. So exactly 1 year is Connecticut a misdemeanor, but in federal immigration law, a felony has dramatic effects on how these people are treated, and so we're trying to sort of modify that on our end. We made a proposal that would allow people on parole to vote. We made a proposal through our office, recommended by the Office of Victim Advocate, to allow persons who are the victims of identity theft, if someone is arrested for that charge and applies for accelerated rehabilitation. Under Connecticut law, that file is sealed, which prevents the victim of the identity theft from getting like a police report or a arrest warrant or a court document, which would assist them in clearing their name with these credit agencies. And so this would create a slight carve-out so that persons who could demonstrate themselves to be victims of identity theft could get access to that information. We made a proposal to modify our criminal statute against unlawful dissemination of intimate images. This was done by the Trafficking in Persons Council that made this recommendation to us. What we really did was just, I think, make some technical, I would say, improvements in the statute. There's no substantive changes, but I think we drafted the statute to take advantage of some other language in our laws, which sort of streamlines it. I think it's a simpler statute and it will be easier to enforce and apply in court. We've made a proposal that persons who are negotiate a range of sentencing options, so-called cap sentences. In other words, they're facing a certain charge that might have a 20-year maximum, but they have an agreement that they can't get more than 5 years on their sentence and they might get less. Right now, those sentences are eligible for sentence review. We've made a proposal that those sentences should not be eligible for sentence review because the person has sort of negotiated a range of sentencing, which is relatively narrow, and is not the kind of case that a sentence review is really designed to address. We've made a proposal that people who are sentenced to jail would have a greater opportunity to seek modification of their sentence under a statute that allows a court to take a second look at a sentence under the sentence modification statute. We've made a proposal that persons who were 16 and 17 years of age and were convicted of misdemeanors, who, if they were prosecuted now through the courts, would be handled through the juvenile court system, but because of the raise the age happened after their conviction, they have these convictions on their record, to have those convictions erased, either automatically if it's within a certain time frame or by petition if it's a later time frame. And we've made a proposal recommended by the Department of Children and Families to assist parents who are incarcerated but are making strides to maintain a genuine parental relationship with their children, to have an opportunity to continue that and not be have their children be taken away from them in some sort of termination of parental rights case in juvenile court. So that's sort of a whirlwind tour through these legislative proposals. It's a lot. We'll see how we go. We intend to sort of hopefully engage with our legislators to be a resource to them to explain these proposals and hopefully gain their support. So let us open this up now to the floor if anybody wants to comment on any of these proposals or strategies going forward that we might employ to try to get them passed. Anybody have any comments or at all about this? Yeah.
So as Judge Devlin mentioned, we're starting to meet with Judiciary Committee leadership and other members. The goal is to meet with all members of the Judiciary Committee. Commissioner Farr has been very helpful in coming to some of these meetings with me, as we did last year. And certainly this is my job to come here as much as I can and to explain these proposals to the legislature, but I would also encourage you to get involved in the legislative process as much as you can, to the degree that you're comfortable with, and really view these proposals as a collective responsibility of the Commission, because some of the stuff is not easy to pass, and we know that. And the sex offender registry and anything to do with child porn statutes is very difficult. And I know some of you have already been doing that, which I really appreciate. But whatever you can say in written testimony to support these proposals, or whenever you testify before the Judiciary Committee, or if you're willing to come with me to some of these meetings, whatever you're willing to do, certainly would be appreciated and helpful.
Okay, great. So we'll sort of keep you posted on how these things work out. The next item is a licensure study. So regrettably, neither Professor Sarah Russell nor John Santa could be here today to speak on that, but this is within their subcommittee on the collateral consequences of criminal convictions. And one thing that they're examining is the degree to which someone's prior criminal conviction should prevent them from getting a license to engage in a certain occupation. Because there are research on this that they've done so far, there is a real long list of professions that are licensed by licensing authorities in the state of Connecticut, where a criminal conviction either is a complete bar or a factor that's considered negatively in whether or not someone should be granted a license or not. And so we're looking at this to see whether, in the appropriate case, the person's conviction might not be a bar to them at least seeking to apply to the regulatory authority to obtain a license to do whatever. I think that many of the people that are probably have convictions, personally, I'd like to really focus on such a jobs they can really get, building trades industry, other sorts of things like that, which I think are good opportunities for people who have been through the criminal justice system, but still could be very, very good and effective employees for these employers. So this is something that we started. This is in its sort of early stages, but it's one proposal that is being worked on by Commissioner Santa and Commissioner Russell. Want to expand on that, Alex?
I think that's exactly right. The question is, to what degree does a criminal record prevent somebody from being able to obtain an occupational license? And it's not exactly an easy question to answer, because for the most part, we don't have hard prohibitions against for the most part, nobody's disqualified from pursuing a license based solely on the conviction. Right? There are a few professions where that's the case, but usually criminal conviction could be taken into account when a board or commission examines somebody's suitability for a license. And so what we're going to do is we'll reach out to some of these agencies, boards and commissions to see if they collect any data on this. And just to examine their processes, what happens when somebody comes before them with a criminal record, and how's that working out. We'll do some research, and then we'll bring it back to the collateral consequences subcommittee, and then eventually to the full commission. So that's the plan, to do some research during the session and come back to you sometime this summer and tell you what we found.
I had a chance to visit you at IMRP on Tuesday, so I got to see the enthusiasm firsthand of all the hard work you do. I just wanted to share, in case it's of any benefit to the Commission, that my former position was at the Council of State Governments Justice Center, which helps to develop the national inventory of the consequences of the collateral consequences of a criminal conviction, or the NICCC. And I was just pulling up on the website the Connecticut listing for licenses, and it lists all the the consequences of a criminal conviction and where they fall in the statutes. It links right to the statutes on their webpage. So if it's any resource to the commission, I'm happy to share the link. It's helpful for me when I come into a state to look for it. It's recently revamped and reposted. It's such a difficult acronym, but yeah, the National Inventory of Collateral Consequences of a Criminal Conviction, or NICCC. And it's a 50-state plus territories guide to all of the collateral consequences resulting from a criminal conviction. The types allow you to search according to education, employment, licensing, government benefits, housing, registration, and more. Benefit, too, is you also can search across different state lines to see the ways that it would vanish. It would differ from one state to the next. But what I heard you say, Alex, in your remarks is that it's more of a matter of some of the statutes kind of allowing discretion to licensing boards to make a determination. So in case there are either external resources or support available for training and support for the boards on how to review a person who applies for a license and has a criminal conviction, that might be another next step. But I hope it's some use to the chair and to the members of the commission.
Yeah, thank you for that. That'd be great use. What we don't know now actually is the degree to which in the real world the conviction is deemed a disqualifier, even though it may not technically be one, whether you have it or not. I just don't know the answer to that, whether that's something where it's not taken into account or just one of a constellation of factors, or if it's seen as sort of a determinative factor. I think that's information that's hard to get, but I think that'd be useful for us to see if we can at least maybe anecdotally get a little bit of that information. But thank you very much for that. Now, is there a big difference among the states in terms of how they treat criminal convictions and licenses?
Mr. Chairman, I have some idea, but not enough to speak about variations. I do tend to find one of the things that's compelling, I think, to policymakers is the sheer number of collateral consequences that result. So the search allows you to provide a type of disqualification or collateral consequence, and it'll give you a total number. And so I think some state policymakers are just struck by how many are on the books because they're very hard to address because they're located all throughout the code. And without a tool like this, it's hard to isolate them. And what I think is helpful, too, is the emergence of best practices in states around the country. And there is a section on the NICCC that includes news and resources, which is a way, I think, to answer your question more specifically, Judge, around what have states done in this area more recently that enjoyed bipartisan support and led to changes, especially more complicated ones like you were mentioning, that it may not be a change in statute, it might be more of training and tracking. And it'd be interesting, I've never seen before, Judge, a list of or data that tracks the approval rate and just how determinant that factor is. I always think so much about how different decision makers have to weight different criteria when making a decision. And it would be interesting to see how an average decision maker weights a record against other factors and how big a determinant that can be. Having been in track some of the discussion in this state on this topic, I was pleased to see the Yankee Institute publish various publications from a right of center perspective on it. And since beginning my new position recently, I haven't been able to connect with that organization. I'd be curious to see if there's still interest and capacity in that organization to be engaged in the topic.
Yeah. I had the interesting experience of being on the parole board prior to the last recession, and then on it while we were in the worst of that recession. And in my experience, what happened was when I started off, parolees could get a job and be expected to get a job when they were going out. When the recession got severe, the first thing that got cut were anybody with a criminal record was in big trouble trying to get a job. And so that was because there was this great discretion. And if you got 100 applicants, the first thing you do is get rid of the criminal records and go with, we had one individual who, down in New Haven, had, I think, 18 parolees employed there before the recession. When the recession hit, he was able to get laid off white-collar people who had better records and more dedication and would show up on time and everything else. And he ended up ultimately having 0 parolees employed there. But as he come out of the recession, I'm sure he's back to now looking desperately to find some parolees to do the jobs because it wasn't a very attractive job. And so it's important, I think, to look at statutes that may artificially prevent somebody from getting a job when the employer would in fact be willing to do that because of the shortage of labor. So this is an opportune time to do that.
I just want you to know from a Department of Corrections point of view, it's going to be important for us to have these types of jobs for offenders because they're able to get higher paying jobs so that they're able to provide for their families, get better homes, restitution, victims funds, and all that stuff. So it's important that we can, if we can, to be able to get them the certificates and even do it while they're incarcerated. So very helpful to us. Mark.
I think, Mr. Chairman, I think Mr. Farr is raising some great points, and one of the real issues that I've heard the Commissioner talk about in our brief conversation so far is ways that you're seeking out interested employers and working with the population as it transitions. And there are a number of major international corporations that speak quite highly of their experiences hiring people with criminal records. And there are ways that states are increasingly trying to recognize employers who are seeking out and hiring people with criminal records and finding great success in it. So I'm thinking there might be an element too, along with the analysis we discussed and along with the outreach and pursuit of data, and along with looking at employment and other workforce issues, maybe additionally looking for ways to really highlight employers in Connecticut that are actively hiring people with records, highlight their successes with working with this population, and looking for ways that a lot of the employment programs that Commissioner runs inside his facilities can better interface with employers so that upon reentry, the people are able to access employment right away. So they're building the skills. I joined the Reimagining Justice Conference at Cheshire Correctional. I remember, Judge, you were there as well, and seeing all the work going on in your facilities. A lot of skills they're trying to develop to be ready for the workforce upon reentry.
I think it's fair to say that access to those certificates of employability is minimal. Not many people apply for them. And I think the reason for that is that they're not really translating into tangible opportunities in the workforce. And so maybe we need to look at that whole idea of certificates of employability to see what are we certifying the person to do. What are we saying about this person? Because just having a piece of paper, the person, they realize it's not doing them any good, and so no one is applying for them. But if it really had some tangible benefit, I think there'd be a whole different sort of set of interest in that. So that's something, this licensure study is actually a broader lens into trying to help people with records get jobs and see if we can sort of take a look at various ways to do that. So anybody else have any comments on that? Great, okay, good, thank you. So the next item on our we proposed a couple of years ago a modification to our pretrial release statutes in Connecticut, which our proposal sort of became blended with a proposal made by the governor and which was put into law. The commission, I think, continues to have an interest in pretrial release and pretrial detention. And so one thing that was considered and was endorsed by the steering committee is to see if there was a possibility of amending our Superior Court rules to permit a modest expansion of the availability of what are called 10% bonds. So when a police department sets a bond, the person who is facing that bond has two options. They can either hire a bail bond agent who will post that bond in exchange for the payment of a premium. And then if that person fails to come to court and that bond's ordered forfeited, that bail bond agent or the insurance company that that agent represents will be responsible to pay that money to the state. The person could post the bond 100% in cash at the police department, and sometimes does for small bonds, and be released then. And then that cash money will be held initially by the police, but then by the court. And at the conclusion of the case, if the person appeared, they would receive that money back. There's also a provision in our rules that a judge has a discretion in an individual case to say, I'm going to set the bond at this amount, which can be posted in cash, or it can be posted by a surety, or it can be posted by the person posting 10% of the amount of the bond with the clerk. So if it's a $5,000 bond, the person would post $500 with the clerk. That'd be held by the clerk. And again, if the person, when the case was disposed of, if the person came to court properly, that money would be returned to the person who posted the money. The idea here is to see if expansion of that 10% option would make sense, to make it automatically available at the police department at the time of arrest for bonds up to an amount of $20,000. So if a police desk sergeant or one of our bail commissioners that goes to the police department and sets bonds, set a bond of $20,000 or less, the person could hire a bail agent to post it, or they could post it 100% themselves, or they could post 10% of the money and would be released. So toward that end, we've drafted a letter to the Rules Committee asking them to consider this and to consider whether this would be an option that they think would be sensible to amend our Superior Court rules to permit that. As we've talked about before when we were, and I don't know what the numbers are now, I'm sure Commissioner Roberge would know, we've got somewhere in the area of, north of 3,000 people being held pretrial in Connecticut at any given time, maybe 3,200. I don't know exactly what the number is, but it's in that ballpark.
It's about 3,500 this morning.
Okay.
Yeah.
And so those are people who have been arrested and are unable to post a bond. And in many instances, for quite good reasons, they're facing very serious charges, and the judge felt a substantial bond was warranted, and they're unable to post it, and they're held in custody while the case works its way through the court. Others, I think it's fair to say it's just their economic situation, makes it impossible for them to post even relatively modest bonds. So I think this would be I know we've talked about more fundamental changes in our bail system. This would be a much more modest change, and I think it would be focused on people of lesser means, but it may, provide an opportunity for some more people to seek release while their case works its way through the court. So anybody want to comment on that? Just general proposal, good idea, bad idea, we sort of think about it?
If all bonds are automatically subject to 10%, even at the police station, that doesn't give the arraignment court judge an opportunity to look at the factual allegations, the person's record, and any knowledge that the judge may have about the situation. And you've tied the judge's hands before he or she even gets an opportunity to make a decision. I'd also say that I think it's a good idea to give a judge an opportunity in any and all cases to set a 10% cash bond. I don't see a problem with that. That actually, I think, gives a defendant more options or more of an opportunity to get out. And I'd say one other thing, which you haven't addressed, and I wondered if the working group talked about this. We have non-surety bonds available in the state. And I've been dealing with them for years when I was a PD and as a judge. And I could be wrong. I think that if somebody violates the terms of a non-surety bond, the state of Connecticut has to sue the person to recover the money. I don't know if that's ever happened. I've never heard of it happening in the time I've been a lawyer and a judge. And to me, those bonds just appear to be illusory. I don't know, so if anybody has any comments about the non-surety bonds, I'd be interested in hearing it.
They're not all that unusually used, but they're not much more than a piece of paper.
That's how I see them, and I can't say I've seen a ton of them, but I seem to see more of them, particularly after someone's been arrested and they get set at the police station. And I'm not focusing on the police necessarily or the bail commissioners. I'm just saying I seem to see those from time to time, and I wonder what's the point. To me, if you're going to give a non-surety bond, you might as well just give them a promise to appear.
I think the cases that we're talking about that would benefit from this change would be in that sort of category. The kind of people that, if they had the means, would have a bondsman come and bail them out of jail on a $2,500 bond or something. The more serious cases are going to come to the judge. Any case where the police department or the bail commissioner sets a bond above $20,000 or above $20,000 would be coming to the court, and then the whole process would work, or if the person obviously didn't post even the 10%. our option now, which we do have, and it's been on the books for a long time, that judges can set 10% bond on motion of the parties, remarkably is rarely used. It's rare for the public defenders to ask the judge to set a 10% bond. I mean, I don't know, I think it's somewhat cultural, quite frankly, but we just don't see that being, we don't see judges denying them in any great numbers. We just don't see that being made available. As I said, I think this is not going to revolutionize our bond situation, but it may have some modest effect on some people that can, through their friends and family, can cobble together 10% and post it with the court, but would otherwise be unable to pay the money for a bail bond agent to post a bond for them.
Okay, if I could make one more comment.
Sure.
I suppose I'm really focused on cases where somebody's charged with something very serious, a sexual assault, something of that nature. And if the person could just automatically post a 10% cash, he may do that, and the person appears in court, and the presiding judge may look at this and say, look at this guy's record, or look what the allegations are. This bond wasn't appropriate, and the judge would have no options at that point because the person's appeared.
Right.
I don't recall the figures. I know we looked at them, and there is a certain amount that will not be subject to collection on the $20,000 and under group. We did look at that, and that is part of the mix. And that was also kind of how we arrived at the $20,000 figure.
Right. So it was
a weighing of
yeah,
risk versus benefit and collection. But the automatic application, to his Honor's point, would be on the $20,000 setting and below. Other than that, it'd be at the discretion of the court once the case got to court.
exactly.
No, just briefly, I mean, part of the idea with this too is this impacts indigent communities, because if they can put up the 10% cash, then whoever puts it up for them, either the defendant or their family members, can then get the money back. Or if they have to pay a bail bondsman, then the money is gone. And the other thing that I thought was interesting, there's data from OPM that was presented to CJPAC that showed sort of what happens to people who are held on bond and how long they stay. So there's and I don't have it with me today, but there is some data that Ivan had done that shows that these folks they stay in jail for about a week. So this ability to be able to post the lower bonds as a cash option also, I think in theory, would help lessen the disruption in people's lives. So being in for a week may not sound like very much for being arrested, but it leads to people losing their housing, losing their jobs. So an ability for sort of lower level offenders who are going to get out pretty quickly anyway, as our data shows, to be able to get out a little bit quicker could have a good impact in their ability to reintegrate back into society and not go deeper into the system.
Yeah, good points. I mean, I think that is, if they don't make bond within a week or so, they're not going to make it. So any other comments on this?
Your Honor.
Yes, yes,
I'm
Chief.
curious whether there could be some exceptions carved out for people who, if they are bonded out on a 10% bond, may go back and retaliate against the victim, maybe a domestic violence situation or something else where, you really want to do what you can to keep them in custody until their time of arraignment.
Who pose the most challenges with
Well,
that?
that's one example, I think. I
Yeah.
mean, there's other types of crimes that law enforcement investigates that perhaps they're threatening a witness or some other situation like that where, a high bond would be called for.
So presumably the police department could set the bond at $30,000 if they, and then there wouldn't be a 10%, automatic 10%. $20,001.
Alex circulated a draft letter to the Rules Committee for his signature and mine, which essentially summarizes this. So let me read this letter and see if there's any objection to sending this letter to the Rules Committee. It's in your packet. You have it. It's dated January 25. So it's to the Rules Committee. Dear members of the Rules Committee, on behalf of the Connecticut Sentencing Commission, we are writing to request you consider a rule change to the Connecticut Practice Book to make the 10% cash bail provision an automatic option for defendants whenever a surety bond of $20,000 or less is imposed. Enclosed, please find a draft of the proposed rule. As you know, the 10% cash option is already authorized in the Practice Book and is available if requested by the defendant and granted by a judge. If granted, the defendants receive their money back once their case is disposed. An automatic option of 10% to the court would assist indigent persons to make bond. It would lessen the burden on those who can barely afford it and may help those defendants who are detained on low-level charges to make their bond. Just parenthetically, last I knew, we had about 500 people held in Connecticut on misdemeanor charges. The proposal was endorsed by the Connecticut Sentencing Commission in its 2017 report on pretrial release and detention. As you know, the Commission's membership consists of all major stakeholders in the criminal justice system of Connecticut, including Superior Court judges, Chief State's Attorney, Chief Public Defender, Victim Advocate, Commissioners of Corrections, Emergency Services, and Public Protection, and Mental Health and Addiction Services, community activists interested in the criminal justice system, the Chair of the Board of Pardons and Parole, municipal police chiefs, the Undersecretary of Criminal Justice Policy and Planning Division, as well as others vitally engaged in the criminal justice system. We realize that the expanded utilization of 10% cash is not a long-term solution to pretrial justice issues. The Sentencing Commission is examining whether Connecticut should move to a no-money bail or in or out type system where persons are detained only upon a finding of flight risk or dangerousness after an on-the-record hearing conducted with proper due process considerations. The Sentencing Commission will continue its efforts to explore a no-money bail system. In the meantime, we ask that you amend the practice book to expand the 10% cash option and improve the pretrial justice system in the state. Thank you in advance for your consideration. Does any commissioner have any objection to us signing this letter and sending it to the Rules Committee, or that it be amended or redrafted in some way?
Mr. Chairman, just in the proposed 10% cash bail, there appears to be a typo that just needs to be corrected. After third line, should be 10%, I believe.
What happens if the defendant fails to appear? Do they lose the 10%?
They lose 100%. Just like on a regular our rule now says that if you post 10% but you don't show up, the full amount of 10% is forfeited, and then the full amount of bond you owe that to the state of Connecticut.
I have a comment about that. So I take it that if you were ordered rearrested and you have a pending failure to appear, or you're ordered rearrested, that you could make a 10% cash bond even on that. So if you're rearrested on a felony, and if your bond's under $20,000, you can automatically post 10% and be out again. And there's an example to me of a case where a judge ought to be able to look at that and make a determination whether a 10% cash bond is appropriate. Maybe it is, maybe it isn't.
Okay.
But I would just think that in certain types of cases, automatically authorizing a 10% cash bond may not be the best option. That's my concern initially.
Well, I think so that would come up. Say someone had a breach of peace charge, and they had posted, say, $1,000 bond or something, and they failed to appear in court, and the judge ordered a rearrest and ordered rearrest bond of $5,000. I mean, it's a modest charge. It had a modest bond to begin with, and now the rearrest bond is relatively modest. In that circumstance, right, Judge White, if that person was arrested on the failure to appear warrant, they could either post the $5,000 bond that the court set or put up $500 with the clerk and hold it that way. If someone had a serious felony, I doubt the rearrest bond would be less than $20,000, but I don't know. But yeah, that's true. That would be do you think this should be, we should have some, see, what we're trying to get at is try to reach people at the police department when they're arrested, not wait till the court process it, because I think at the police department, that's where I think people would have the best opportunity to be released, and I think it'd be difficult. We don't want to ask police officers to make these sorts of decisions about what's on one side of the line or the other. I think it'd be an easier applicability of it if it was just sort of across the board. But I suppose we could exclude failure to appear arrests. Are you making a motion to amend the proposed rule to exclude those?
I'm not indicating that somebody shouldn't be able to make a 10% alternative from a police station in an appropriate case. I just think that, there's a dividing line somewhere. If you're talking about somebody who's been charged with a larceny 6 or breach of peace or something relatively minor, of course, you ought to be able to put the 10% down. But if it's under 20,000 and the person had a pending felony and got arrested, it has a fatal penalty first degree pending. It just seems odd to me that that person will be able to make a 10% cash bond without a judge looking at it. Or if it's a sexual assault or something more serious. And before you indicated that it was a real serious charge, the bond would probably be over $20,000. Not necessarily. I mean, I would expect a lot of times it would be, but it depends on the judge who's setting the bond. One judge sets higher bonds than others do. So, perhaps a starting point would be to say excluding failures to appear, but I don't know if others have the action.
I don't have an issue with it, but I still think that someone who, on a failure to appear, had the money would hire a bondsman if they couldn't pay the 10% and still get themselves out. So I think either way they would get out, but instead of the bondsman getting the money. But I can go either way.
Well, that's what I was going to say. What would happen is, if on the FTAs, if they simply get the bondsman, they get some kind of payment plan, because they take you out on credit, basically, and they'd have a payment plan, which is the way it works now. And, I mean, that's nothing wrong with that. Actually provide a service to people who don't have ready access to large amounts of cash, and so they extend credit.
So my only comment is, I think judges get to weigh in with some discretion, because if somebody's failed to appear, the judge sets the rearrest bond. I think to some extent over time, if this rule were enacted, bonds would go up if the judge really had an interest in, because they would be the one that would know that individual. A lot of times these are GA people. They're people who don't appear. The judges know who they are, so they would know to set the bond a little higher if they didn't want people to be released on the 10% cash option. So I think over time you have judges who will be familiar with it. It's a training issue. If you really have a concern about this person and you don't want them to do 10% cash, set the bond higher than $20,000. So I think there's a lot of different ways that it can be approached. And failure to appear has happened for different reasons. I think giving the judge the ability to set the bond at the rearrest gives them that discretion.
It may very well be correct that the unintended consequence of a $20,000 dividing line may in fact push bonds up. But perhaps we could consider the thought of, if the court is setting the bond on the rearrest warrant, and the court's making a decision, the court ought to have the ability to say cash or surety only, rather than, we could tweak the automatic provision. On a rearrest, a court's taken an action. The defendant failed to appear in court, court issued a rearrest warrant. Court set bond, ought to give the court the authority to say cash only, cash or surety only. And then the court can reassess the situation if and when the party's arrested.
What the rule that we proposed, okay, the first clause in that rule says, unless otherwise ordered by the judicial authority. So I would interpret that to mean that if a judge felt that that particular charge or that particular was not suitable for a 10% bond, they could say, look, rearrest ordered, bond at $10,000 is set, no 10% option on this bond. The judge could say that. And that would then, all the actors going forward in the criminal justice system would respect that, and then the person would come back before the judge or a judge at arraignment, and then it'd be hashed out and whatever. So I think the rule contemplates judicial discretion, sort of going both ways here. What we're really looking, the sort of heartland that people are looking for are people who are arrested on relatively minor charges. The police believe a $5,000 bond, something like that or less, is appropriate, and they're unable to, by passing the hat around with their family or something, they may be able to get enough money to get out and will come to court, but would otherwise be held in jail for a week or 2 weeks or whatever while the case it works its way through the court. But Judge White, does that language in that introductory clause, does that address your concern?
Yeah, I hadn't thought about the way you put it.
Yeah.
I suppose it does address that. I still would like to give some more thought to this.
Okay, sure.
Objection to the letter or the request.
Yeah, and look, the Rules Committee is going to have hearings on this. The Rules Committee, they may change it 100 ways or may not adopt it at all, but this is just something to bring to their attention. And if they pass it, I think the branch should spend some time explaining this change to the judges at our meetings and to basically raise their consciousness about their different options on this stuff.
You know, we're so used to the commercial bail bond industry here in Connecticut, but there are states out there that prohibit this industry from existence, right? Oregon, Wisconsin, Kentucky, some other states. And in those states, everything goes through the court system whenever a bond is imposed. And on top of that, you know, this is the only country, along with Philippines, we're the only two countries that rely on bail bond industry at all, right? And those other places, again, things go either bonds go either through the court system or they don't have money at all. And you know, overall, I'm glad we're taking the step. It's hopefully we're taking a step. It's a good step forward. But I'm hearing some concerns about people who perhaps should be detained, but they're not, which is a very much a legitimate concern. There are plenty of people who post $20,000 bonds and $50,000 and $100,000 and $1 million bond, right? And we know what to do about that. We've discussed that. We couldn't quite get to an agreement, but we know what to do about that. And the other very legitimate concern of people who are in, who probably should be out, but they can't come up with even a modest amount of bond. So I would strongly encourage us to think about why money should play any role in the pretrial justice system, and why that should matter at all, how much money you have with respect to who should be detained and who should be released. And hopefully we'll continue to examine it, but this is a good first step.
Mr. Chairman, I would just hope that the commission will make clear to the Rules Committee at any hearing that we are not looking for the unintended consequence of raising bonds by virtue of this rule, and obviously the purpose of the rule is to aid and assist indigent people and to keep low level offenders out so that they're not detained for pecuniary reasons only. And so I would hope that the caveat, unless the judicial authority orders otherwise, will be sufficient to alert judges not to unnecessarily raise bonds.
This is something to help indigent people, another option for them to make modest bonds. That's really what it's all about.
Great, thank you.
So, does anyone have any objection to us sending the letter to the Rules Committee as written? Okay, good. Seeing no objection, we'll take that up, and we'll keep you posted at how this works through the committee's process. So our next item on our agenda, we have one of the unfinished items of business from a couple of years ago was a letter from the governor asking us to take a look at Connecticut's various diversionary programs. And there's probably a dozen of them, and to take a look at them to see if there's can be whether they're working, how they're being used, what the sort of are judges granting these programs at regularity or not? Should they be maybe condensed or reformulated some way, and just sort of generally take a snapshot of how these diversionary programs are working and see if maybe a different organization should be considered. And so that's been something that was sent to us as a request from the governor a couple of years ago, and because of some other projects we never got around to looking at it. So I'm pleased to report that Judge Hillary Strackbein has agreed to chair a work group to take a look at that. And I would ask anybody who's interested on the commission to participate in that, you're welcome to. Just contact Alex. Specifically, though, I'd ask Commissioner Kane and Commissioner Rapilla, if you could designate people on your staffs to participate, we would appreciate that as well. And as Court Support Services, I think would be very useful in terms of that. I also think that this work group, that diversionary program part of it is important. There may be other things that would be on the sort of agenda to consider. So let me open the floor. Does anyone see any criminal justice policy issues that might benefit from examination by a work group? Commissioner Zito.
The Connecticut criminal defense lawyers actually have been looking at this issue because there isn't continuity among the programs in sealing them. Okay. So there are a few programs that don't require that they be sealed when we feel that all of the programs should be consistent with ceiling application. So that's
Okay.
one issue that I think would be prudent to look at.
That problem was recognized, that there was some programs that were sealed immediately and some were not. I actually thought we had looked at that, but probably imperfectly, because I remember that coming up, that whole idea. I agree with you
think
100%.
Yeah, I think, I may be wrong, but I think one of them was the domestic violence, one of the programs for domestic violence offenses.
Part of our legislative package actually includes a proposal to make it consistent across the board, and we've been discussing that with legislators. It's not very, I don't think it's very objectionable, just to make it consistent. So that's something that maybe will be addressed,
Okay.
be discussed in the work group, but we have it as a legislative proposal, and I believe it's going to be raised.
Okay, great.
I also think you should look at the issue of whether or not we don't nollie cases anymore, because it's my experience that if you go to court and the case, the case is very weak and it's decided that maybe there doesn't need to be criminal intervention in this case, there's a tendency to say, well, but we got to put them in a diversionary program, because that's why we come up with some program, some community service or something, and that there's a tendency not to want to use nollies as much as we used to in the past when there's not a valid case. Maybe you should take a look at that.
I think the fact that people do not make a forthright admission of their guilt in public as a systemic, I understand why Alfred pleas are very useful in terms of docket management. I understand why in some cases, there is this genuine dispute about what happened, and so the Alfred plea allows the system to kind of work as well as the sort of plea negotiation process. But it's not an exception anymore. I mean, it's become sort of the standard. For those of you who don't know about it, in court, someone can enter a guilty plea under the Alfred doctrine when they can not admit doing what the state says they did. The state says you stole this car, and you're caught in it, and they plead Alfred, saying I plead guilty, but I don't admit stealing the car. What I admit is that the state has enough evidence that I probably would be convicted if I went to trial on this. It's a subtle difference, but a real difference. And it may be that we could create, like the federal court does, or some incentive for someone to make a forthright guilty plea, and they get credit for that. They get their sentence maybe lessened for that, because it might just as me speaking, I just think systemically that has a pernicious effect of people not acknowledging. They can claim that, well, look, I had the whole arsenal of the state prosecutor's office, trained on me, and what am I expected to do? I'm just going to bend to them, and they bend me to their will. That's a regrettable thing. So I'd like you to put that on your agenda, and to see if there's some that makes sense or does. We could take a look at other states. Are Alfred pleas being used extensively in other states? Is Connecticut any different than any place else? I doubt it, but maybe we are. But just toss that out there as something to at least look at.
The judge has the option, in my view, of either accepting or rejecting an Alfred plea. And I can tell you, I don't take them in sex assault cases because I'm probably going to order sex offender treatment. And it's my understanding if you go for treatment and you don't fess up to what you did, you're going to get kicked out and you're going to be back on a violation of probation in any event. So I don't even go there on sex assault cases. And in other cases, it will depend on the nature of the allegations. I think accepting Alfred pleas sometimes makes it easier for the lawyers, both the state and the defense, to get a resolution that everybody agrees upon. And it allows the defendant to save face, although it's pretty clear that the person is going to be convicted. I'd be interested to see if we have any stats about how many Alfred pleas are taken, because maybe there are a lot in some jurisdictions and virtually none in others. One of the other things I'd be interested in knowing, if there are any stats or data on it, is how many people use multiple pretrial diversionary programs. I can't tell you how many times I've had a defendant come in front of me and he's applying for family violence education program and AR and the drug education, and it's as if with some defendants we got to use every pretrial diversionary program before we get any place. And to me, I'm glad the pretrial diversionary programs are there because I wouldn't want to see anybody saddled with a criminal conviction right off the bat. On the other hand, I don't think you're doing people a favor, particularly young people, if they get 4, 5, 6 pretrial diversionary programs and then they get arrested again and they get a felony record or they go to jail and they say, what happened? Nobody ever did anything before. So you may be, not you, well, we may be doing a disservice to some people by letting them have too many diversionary programs because they don't take the law seriously.
I agree. I think we should take a look at Alfred pleas and see why such an increase in the use of them. At one time, it was fairly widely accepted that when people admit their guilt, that's something that a court ought to consider in deciding whether that's a mitigating factor. And the admission of guilt was really the first step to rehabilitation, we used to say. Nowadays, with so many pleas being accepted, and one time I was thinking maybe 50% of the pleas accepted are Alfred pleas. You thought it was a lot higher than that when we talked last week, and that's kind of astounding. And I do think we ought to look at it. That Supreme Court case that decided it was a death penalty case in which the only way the defendant could avoid being exposed to the death penalty was by pleading guilty. And in that case, the facts were the state's evidence was very strong, the government's evidence was very strong, and the court said under those circumstances we will accept an Alfred plea. But the law was pretty limited, and I think we've gone a long, long way from that.
Well, as a private practitioner, we use Alfred pleas because defendants will agree with some of the facts the state alleges, but not all of the facts that the state alleges. And they're willing to take responsibility for what they actually say they did, but they're not willing to take responsibility for everything they're accused of. And they play a very pivotal role in plea negotiations, particularly where I just had a case where a client had a violation of probation pending along with a new underlying offense. And he was stuck between a rock and a hard place because he was going to get more time if he contested the violation of probation for the arrest alone. You know, the standard obviously is different between going to trial on the new case and whether or not he'd be found to have violated his probation. So if he did not take this plea agreement, he would have gotten much more time on the violation of probation, even though he could have possibly and probably won the underlying new arrest case, because all they had to prove is that there was probable cause that he was arrested while he was on probation. So he was between a rock and a hard place, and he needed to plead under Alfred to the new case just because it was a more practical result to take a plea and avoid getting more time on the violation of probation, even though he may have won the underlying case. So it concerns me greatly that I'm hearing from both Mr. Chairman and Judge White that you don't take Alfred pleas in sex offender cases, and I understand why, because it's true with the sex offender probation that they have to admit their guilt, but I specialize in representing people accused of sex offenses, and I can tell you that without Alfred pleas, which I've never had one not accepted, to be quite candid with you, I don't think I would have been able to resolve 60 or 70% of those cases. And the way that we get around that is we put them in private sex offender therapy, which in my experience has been more beneficial to clients anyway than going through the group therapy at times. But particularly in cases where you're representing, I represent a lot of grandparents and older people accused of sex offenses, they in many, many cases will accept responsibility for some of the things they're accused of, but not all of the things they're accused of. And the witnesses are not always that reliable. So it's almost appalling to me that Alfred pleas are rejected in sex offender cases as a matter of course, because that is, linked directly to a sex offender treatment program, which I have to say we question the validity of that polygraph course that they require to begin with. So I certainly feel that there is a necessary and a place for Alfred pleas in Connecticut. And it's not that people are not taking responsibility for anything, it's that they're not taking responsibility for everything.
I'm
I
just saying we
understand,
should study it.
but to hear that Alfred pleas aren't accepted in sex cases as a blanket rule, that's very upsetting to hear, honestly, as a criminal defense lawyer.
Well, to me, the fundamental premise of the sex offender treatment is you admit doing what you admit you violated these social norms, and then you sort of come up to the place, well, why did this happen and how can I prevent it in the future? That's sort of the fundamental idea of sex offender, at least it's a connection kind of sex offender treatment that we have. So I still think that that's important. It seems to me, anecdotally, that they're used a lot, and maybe there's a way to sort of bend the curve around a little bit. But I think this is something we'll study and sort of see. I may be proven 100% wrong.
If someone wants to enter an Alfred plea in a sex case, I will ask, well, what's the reason for the Alfred plea? And if the person disagrees about one of the elements or says, I did not sexually assault somebody, I'm not going to take the plea because I don't take guilty pleas from innocent people. To me, there's nothing other than killing somebody intentionally, there's nothing worse you can do than sexually assault somebody else, particularly a child. So if you're pleading Alfred because you didn't do it or you disagree that there was intercourse or some essential element of the crime, I'm not going to take it. And we have a statute in place, I don't remember the number, but it specifically says if you are on a probation for a sex offense and you get sex offender treatment and you are put out of the program because you won't admit that you engaged in a sex assault, that's a violation of probation. So I don't really see the point in accepting an Alfred plea in a sex case because if you're saying you didn't do it, you're not going to get through the treatment. We're going to be right back there again.
So we'll just take a look at this. I think this is what we do. So if anyone would like to participate in Judge Strackpine's work group, contact her or me or Alex, and we'll arrange for that. And if you need like logistical sort of stuff, we can work on all that, rooms and things like that. And if anybody has any other ideas for the sorts of things that we might be looking at, we can certainly pivot to that. We did a lot of work last year. We have a lot of legislative proposals. We'll see how those go. So we're sort of pivoting to some different ideas, hopefully. So any other comments about anything from any of our members? Oh, yeah. Right. One more thing that I would think we should look at is this. And Connecticut, in the late 70s, adopted the Model Penal Code, and we adopted the Model Penal Code definition of self-defense, which is a recognized defense. It justifies what would otherwise be criminal conduct. And it's but to explain self-defense to jurors is it sounds simple, but it's not simple. It sounds simple. Look, you defended yourself, but it's not simple. And so it's sort of created this jury instruction that is just about impossible for ordinary citizens to understand. And so they sort of just listen to the judge, their eyes glaze over, and they do the best they can in the jury room. And looking at this thing and working on this instruction, because I'm also involved in the criminal jury instruction committee, our committee has come to the conclusion that the problem is really not with the instructions, the problem's with the statute. That maybe we need to take a look at whether this concept of self-defense could be explained in a clearer way by maybe trying to get to the same idea, but maybe with a slightly different statutory language. So I would like to see if we could take a look at that. Maybe look at what other states do, non-penal code states. Like in the United Kingdom, the jury's asked one question: was the defendant's conduct reasonable? That's it. And that's what they decide. Was the defendant's conduct reasonable under the circumstances of the case? If they find that the person's conduct was reasonable, they'll vote self-defense. If they find it was not reasonable, they won't. So, I mean, it's just a different approach. And again, I'm not categorically saying one way or the other this would be a big change in the law, but it might be something. I don't know anybody else who actually would have the interest in looking at this or has a connection with the academy that we have to sort of really have some in-depth research done on this topic. So that's something else that I think might be create a different work group or something, or maybe somehow work with our existing groups on that. So with that said, yes.
I spent a lot of time representing young people. And particularly thinking of kids between like 18 and 25 or 26 when their brains are still developing. And I've long thought that we might explore in Connecticut some vehicle for kids to, other than the pardons process, for kids to earn their way off of felony convictions. Because when they get strapped with felony convictions, as you know, in their late teens and early 20s, it's a barrier to their growth and progress in life for a very long time, for the rest of their lives, unless they get a pardon. And I was thinking that maybe we could, I find, first of all, in the GA courts that kids are regularly convicted of felonies, and I think that they're different than adults, even though they're considered adults and they're out of the juvenile system. And I think that it would behoove us to find some way to incent kids to make beneficial changes in their lives that could possibly earn them redemption outside of the traditional pardons process, which generally takes longer. So that's something that I've spoken to the Public Defender's Office about, particularly Chief Rapillo, because she's obviously had a great interest in working with kids. Issues, and I think that it's something that maybe this body could explore to address, having a population of young people who can't find work and can't get school loans and who are finding it difficult to turn their lives around once they're convicted of a felony at a young age.
Well, I would think our collateral consequences committee, I mean, that's exactly the sorts of things they look at. Anybody else have any further comments? Okay, so I'll declare the meeting adjourned. Our next meeting is going to be March 28th at 2 o'clock. Thank you very much.